The unsworn opinions of persons who aren't expert witnesses are rarely admissible as evidence nowadays. The history of that rule dates to the early 19th century case of Wright versus Doe by devise of Tatham. John Marsden wrote a will, leaving valuable real estate to his servant, George Wright. After Marsden's death, Sandford Tatham, Marsden's heir at law, and Doe, Tatham's tenant on the disputed property, sued to set aside Marsden's will and evict Wright. Tatham and Doe claimed that Marsden had been developmentally disabled, wasn't competent to handle his own affairs, and that Wright had obtained Marsden's will by fraud. Wright sought to prove that Marsden was mentally competent and able to handle his own affairs. Wright sought to introduce 3 letters written to Marsden during his lifetime. All 3 authors knew Marsden, addressed him respectfully, and discussed matters as if writing to a rational and competent adult. All the authors were deceased when this trial began. After Marsden's death, the letters had been found in Marsden's room, with the seals broken. There was no evidence regarding who had broken the seals, and no evidence that Marsden had responded to the letters or otherwise done anything with them. The letters were admitted and read to the jury at the Lancaster Assizes. The jury found for Wright. Tatham appealed, and the King's Bench reversed, ruling that the letters were inadmissible unless connected with some act done by Marsden. Wright then appealed to the Exchequer Chamber.